welcome back to the Wellness Paradox podcast. I'm so grateful that you joined us on this journey towards greater human flourishing. As always, I'm your host, Michael Stack, an exercise physiologist by training and a health entrepreneur and a health educator by trade. And I'm fascinated by a phenomena I call the wellness paradox. This paradox, as I view it, is the trust, interaction, and communication gap that exists between fitness professionals and our medical community. This podcast is all about closing off that gap by disseminating the latest, most evidence-based, and most engaging information in the health sciences. And to do that in episode 68, we're joined by Barbara Zabawa. Barbara is a lawyer that specializes in health and wellness law. So you heard me right. This is going to be a legal discussion, which is the first time we've had this conversation on the wellness paradox. And this is a critically important discussion because it gets to the heart of mitigating the risk in our business. And this is the risk for people who are independent practitioners and fitness professionals, the people that are 1099 contractors in facility, and even the people that are employed by facilities. And in terms of risk mitigation, this is kind of all about understanding where your scope of practice starts and where it stops, as well as, what are the benefits and limitations to documents like waivers and informed consent. I realize that legalistic discussions aren't the most exciting or engaging, although Barbara has a lot of energy and passion for this area. So I think you'll find at least that to help this conversation. But even though it may not be the most exciting conversation to have, it's still a critically important conversation to have because it's what protects you in the business that you have of helping people lead healthier and more fulfilled life. So it's a conversation that, although we may not get super fired up for, we definitely have to have and have to understand. Any information we'd like to share with you from the day's episode can be found on the show notes page by going to wellnessparadoxpod.com/episode 68. Please enjoy this conversation with Barbara Zabawa. Today, we're delighted to be joined by Barbara Zabawa. Barbara, thank you so much for joining us.
Oh, thanks, Mike, for having me.
Yeah, I'm super excited to have this conversation. We connected via a mutual connection of ours, Debbie Bellinger, who runs a wellness course that we both spoke in. And, you and I had a conversation initially about what you do, which is the field of wellness law and some of the things that, I've been doing. And I was just recently on your podcast, and now you get to be on my podcast. So I'm excited to have this discussion. Like I said before we got on air, this is the first time we've actually had a lawyer and a legal expert on the podcast. So I think this is going to be a neat conversation. And to jump off, tell us a little bit more about your kind of unique background and give us some context for the conversation.
Yeah, well, so I got a degree in public health before I even went to law school. So the whole idea of health promotion, disease prevention was very top of mind. And in fact, I had a workplace wellness fellowship before I even went to graduate school. So I looked at workplace wellness programs in Europe for a year before going to University of Michigan for graduate school.
Go blue, go blue.
And then when I was in graduate school, I decided through one of my professors that law school might be a good fit for me as a next step. So I went to law school, came back home to Wisconsin, University of Wisconsin, went to law school here. And there was no such thing as wellness law. In fact, I would argue that it's still very much in its infancy, but health law was very much a practice area. And so I ended up taking a lot of courses in health law. And after I graduated from law school, I got another fellowship. I did some advocacy for insurance clients, people who have insurance denials, health insurance denials. And then I've clerked for a federal judge before moving into the law firm world, where I was involved heavily with traditional healthcare law, representing hospitals and doctors and health insurance companies. Those are the primary clients of health law practice. And I always had something tugging at me, thinking it's interesting and it's important and it's highly regulated. So I was learning a ton about operating in a very highly regulated industry. But I still kept going back to the days where I was looking at health promotion and disease prevention and wellness and workplace wellness. And so eventually I listened to that inner voice, and 8 years ago started my own law firm called the Center for Health and Wellness Law, and struck out to create this new practice area, wellness law, which I view as a combination of traditional health law, employee benefits law, and employment law. And so a lot of those areas of law from those three practice areas that intersect in the wellness field, particularly if you're looking at corporate wellness. But elements of each exist, and it's a fascinating area of law, not as highly regulated as healthcare, but because there's this fuzziness about where do you cross the line between delivering healthcare type services versus wellness services, one being very regulated and one not. Where is that line? There's a lot of confusion and a lot of questions about what can I do as a wellness practitioner? What can I do without running afoul of any of these laws at the state or federal level? And so that's really kind of my practice area now, is guiding people who are oftentimes not licensed healthcare practitioners. But they operate in a space where they're trying to improve the health or prevent disease of their clients. And so there's expectations on both sides, driven oftentimes by the more traditional healthcare space, but doesn't technically apply. So trying to guide them through that and mitigate their risk as much as possible when they're trying to, provide those, what I view as very important services to clients.
Yeah, that's a fascinating setup for this discussion, because you're right. It's this blend of, as you said, like employment law, health law, and this kind of fuzzy area that we exist in, which was almost part of the conversation that we had when I was on your podcast as well. I'm curious, before we dive deeper into some of the legal questions here, who is the typical person that you work with in your practice? Are you working with individual wellness practitioners? Are you working with organizations? Who you tend to find gravitates towards your services?
I'd say both.
Okay.
I have a good mix of companies that deliver wellness services, oftentimes in the workplace. So they're corporate wellness vendors. And then I also have a lot of clients who are individuals, they're coaches, or some individual practitioner, holistic health, integrative health, trying to look at health from a different angle than and outside of the traditional medical complex. And they're needing help with starting their business, creating documents that protect themselves, have questions about insurance and taxes and all those kinds of questions. In addition to, what can I say? What can't I say? Can I take this assessment? Can I tailor a program specifically for this person based on their medical needs? Those kinds of questions are the questions I get. So yeah, my clients are a mix of companies and individuals. I also do have some traditional healthcare clients. I have the insurance company here and there. I have the medical practice here and there. I do a lot of work in front of licensing boards. So individuals who do have a license and maybe have received a complaint against that license, navigating those waters for them and advocating for them so that they aren't disciplined by the state licensing board. So that's a lot of my work.
Got it. So a healthy mix. That's great.
It's interesting.
Yeah, I bet. Well, and kind of on that note, we're going to get into some of those interesting nuances that exist in your world. And before we launch into this, obviously we're going to be starting to talk about legal matters here, and the standard disclaimer applies that your rules differ from state to state, situation to situation. Always consult your own legal advisor, and we'll have some contact information for Barbara on the show notes page if you do have questions that you think she could be helpful answering. But don't take this as chapter and verse blanket advice during a podcast, especially when it comes to legal matters. But I guess the jumping off point that I want to start with here is what are some of the, I guess, the thorniest issues that you help people navigate, like incorporating and tax structure and all those things. I feel like that's fairly boilerplate for the most part, but I'm sure there are some very thorny issues around things like what can you do, what can you say, how can you represent yourself. I'm curious, what are those, and what should our audience know about those things?
Yeah. So what I see a lot of my clients struggling with is, they don't have a license to practice nutrition counseling or dietetics. They don't have a license, of course, to practice medicine or nursing or psychology. But they have knowledge, a lot of knowledge about, maybe from their own personal experience, about what worked for them, what helped get their cholesterol under control, what helped manage their diabetes, what helped make them lose weight, whatever it is that, gives them the drive to do what they do in the wellness space. They want to share that knowledge. And there's this temptation when you're working with clients, whether it's in a facility or it's in your own LLC or solo practitioner space, to talk to your clients about their health. Ask them questions like, do you have a history of diabetes? Do you have, let me ask that you go get these labs and let's check all of your baseline measurements. And then from there, we can make decisions. We can decide, okay, this is what I think you should do to manage these numbers, to get these numbers in the standard range, whatever it might be. That's very tempting.
Yeah.
But that is when you start tailoring your services based on the medical needs of your clients and making judgments. That is the practice of a licensed profession. Most of the time, medicine. But if you're like a stress relief coach, and you want to help people manage their stress, it might be tempting to talk about things that might be causing your clients to feel depressed, and your clients are more likely to start divulging all kinds of personal problems and hoping that you can guide them through that. That's a little bit of a danger zone too in the practice of psychology. If you're trying to diagnose, well, it sounds like you have anxiety or, depression or PTSD or something along those lines, as tempting as it might be, and as knowledgeable as you might be, because maybe of your own experience, you can't give the impression that you are acting as a licensed professional. You can't let your clients have the same expectations of you as a licensed professional, because in most states, the unlicensed practice of a profession, of a health profession, is usually a crime. It's oftentimes a misdemeanor, so not very big of a fine, not very long of a imprisonment, but it's still a crime. And you don't want to be the poster child for that. And there have been some cases, especially in the nutritional counseling world, especially in that world, where dietetics licensing boards especially have gone after individuals who have been trying to give very specific advice on what people should be eating and why they should be eating it based on their, health history.
Yeah. And so I want to get to the fringes of this where it gets murky in a second, but this is largely an issue around what we'll call scope of practice, right? Like what you can do and what you shouldn't do. And so help are largely our audience of fitness professionals understand based upon what the law exists around this. What would you, as a wellness lawyer, define a fitness professional scope of practice as?
Well, I would say educating, informing, demonstrating, exercises. I know that the fitness industry has assessments, and so I do think those are important to do. They're a little different than, say, like a health, like what you would get in a physician's office. But I think it would be negligent to not know if the person that you are working with is susceptible to, cardiac arrest or something like that. And that's incumbent upon of course, the client to tell you as well. So having those disclaimers, those documents, those warnings in place, which I think most facilities would have. But if you're a solo practitioner, maybe you don't have the same kind of resources, but making sure that you understand the limits of your clients, and then not trying to diagnose or treat any conditions. Maybe your client does have a propensity for cardiac arrest. Well, you're not there to treat their heart problems. You're there to help them, get into shape. And maybe they're there on a doctor's order, which would be great, because then you are kind of working in the orbit of that physician, and that's really good. But if they're there of their own accord, just for fitness professionals, there's quite a few cases actually where a fitness professional was found negligent in not doing a good enough assessment of their clients and pushing them too hard where they get hurt. So that's I think a really special consideration for the fitness industry that they have to keep in mind. Because people can overexert themselves and get hurt. And then they're of course going to blame the fitness professional if that happens.
I'd like to take a quick break from today's episode to tell you a little something about one of our sponsors. As all of you are well aware, addressing the wellness paradox is a lifelong passion project for me. And when you're going to go on a long journey, it's difficult to go it alone. You need to find like-minded individuals that are willing to go on that crusade with you. And that's exactly what I found at the MRF Institute. The team over at the MRF Institute creates educational content for fitness and wellness professionals who are serious about becoming a part of our healthcare continuum. Getting on the healthcare continuum is all about leveling up our skills to be looked at as that valued resource provider. The wellness paradox is certainly an avenue for you to do that, but we need many different levers to pull if we're going to get there. And the MRF Institute is definitely one of those levers. You can go to their website, mrfinstitute.org, to find all kinds of great, informative, free informational content. And if you choose to engage with any of their paid content, they've created a coupon code specifically for Wellness Paradox listeners. You can enter in WP 2022, that's WP, and then the number 2022 to the website at checkout to receive a 15% discount on your purchase. I highly recommend you go check out mrfinstitute.org. Now back to today's episode. Yeah, and from what it sounds like, it's kind of what you would expect is, hey, your job is to be able to evaluate and then prescribe an appropriate workout for your client and make appropriate modifications. And I think that makes sense to everyone. And there are, of course, screening mechanisms in place, and many of our audience will know of the PAR-Q, the Physical Activity Readiness Questionnaire, the ACSM's pre-participation screening for exercise, and those are great resources. What I'm curious about is where the lines start to blur here, and this is always, this is why, people like you who work in the field exist, because the lines do blur. So I'll give a scenario, a client who comes to a fitness professional who has a couple of chronic cardiometabolic diseases. Maybe they have diabetes, maybe they have, hyperlipidemia or something like that. And they're clearly working with this professional because they want to make that issue better. where does what that professional can say start or stop with regard to basic nutrition advice? Like, hey, you should eat more fruits or vegetables. Like, I don't think anyone would dispute that that's not a good thing to do. But if you're doing that in service of addressing diabetes or hyperlipidemia, so I guess that's how do we navigate this gray area as fitness professionals so we don't step over the line, but we also can accommodate our clients' needs to a certain degree without having to say, I can't answer that because I'm not a licensed professional.
Yeah. Well, general knowledge and information is fine. I mean, there's the First Amendment that protects free speech. And as long as what you're saying is generally known, not false or fraudulent or anything like that, that's okay. You can educate people. And so your client who's coming in with all of these chronic conditions, you can educate them just as well as they could look it up on the internet. You're just there to kind of interpret and give them some guidance on what the information is out there on these conditions and things that you can do to help. But then making sure you also have the disclaimers somewhere, and that the client is aware that you are not advising them, that anything you tell them, they should be sharing also with their licensed primary care provider or whoever, and that they should not be using you as a substitute for that. So yeah, I mean, giving people information is absolutely fine. And that's really what I encourage my clients to really focus on, is educating, informing, supporting, holding people accountable to reaching their goals, and helping them frame those goals. But not telling them, this is what you have, this is what you need to do to get rid of it. And, here's a meal plan for you, specifically for you. I mean, those are the more dangerous things. Again, the tailored advice. So the more general you can be and supportive you can be, the better you're going to stay within your scope.
Got it. So what I'm basically hearing there is, hey, the general knowledge that exists out there that you want to disseminate is great. But as soon as you get to the degree of specificity where I say, this is for you, and particularly, this is for you to help you address XYZ condition, that crosses that boundary.
Yes.
So I guess, with that said, you work both in the fitness and the wellness space. And so I'm curious to ask you in the wellness space, because this starts to get into, psychology a little bit and kind of overall well-being. That even seems like it's a little bit murkier. Like, when does your general wellness assessment bleed into a psychological assessment that might get you out of your scope? So I'm curious, what are the big kind of thorny issues that people are facing in the wellness coaching space that might be different from what we face in the fitness space?
Well, I mean, I think when you start doing assessments in the wellness space, that I don't think that's as necessary to really be within your scope as a coach, a wellness or health coach. That and so I do have a lot of my coaches who want to order labs, or at least have their clients get labs, like direct access testing labs that are, they can get themselves, or bring in their lab results from their physician and then go over them with them. And that's the job of a licensed practitioner. Yeah. And as soon as you start looking at labs and then talking about them, I think that you're running into scope of practice issues. I mean, is that really what you as a coach are there to do? And so that I would discourage, people in the wellness space from doing. And because they're oftentimes, in the health and wellness space, looking at diet and nutrition more closely, looking at lifestyle, and are there, unlike the fitness professional who's there to really, let's do a workout here. The whole point of a coaching session and wellness session is to talk about whatever the topic is. And so there's this temptation by the client or by the coach to divulge things that it's not the point of the session. And so I think there's a riskier environment for crossing the line in a coaching session.
Yeah, I agree. Yeah, most definitely. And that's kind of why I asked the question. So a lot of this comes down to, I mean, what we're really talking about, what lawyers do an amazing job of, the good lawyers at least, help you mitigate your risk, like help you make sure you stay in your lane so you don't end up being the poster child for some untoward event. So talking to our audience of fitness professionals, presuming that some are in facility and employed by somebody else. Some might be in someone else's facility in a 1099 contractor, and someone just maybe doing this on their own. Broadly speaking, what are some specific things that fitness professionals can do to mitigate their risk and liability in the field?
Well, I think for those who are working in facilities, the infrastructure, I bet, is already in place where they're getting clients to sign waivers and consent forms, and understanding what the purpose of those forms is. And that is, you're basically informing your clients before they start using your facility and your services as a fitness professional, understanding the expectations of what those services are and what they're not, and the risks that are involved with undertaking those services, and that the client is choosing to assume some of those risks. Because there are no shortage of lawsuits against fitness professionals and the facilities that hired those professionals when individuals get hurt. And so making sure that you as a fitness professional, if you are involved at all in the process with having clients sign the waiver forms and then consent forms, explaining it to them so that they at least understand what they're signing. And then maybe, if you can, better practice yet even is to make a note that you actually had a conversation with them and explained the documents that they were signing, the waiver forms, the consent forms, so that should anyone ever complain, you can point to your notes and say, no, not only did they just get the forms, but I actually took the time to explain what these were. I think that would be a great way to mitigate your risk in the facility, as well as, of course, in your own practice. I mean, because there is no other, you're probably alone and you're not going to have support staff that might do those kinds of waiver documents on your behalf. But I think it would reflect really good upon the fitness professional in either case, as an individual practitioner or as an employee of a facility, to understand those forms that clients are being asked to sign and talk with them about it, ask them if they have questions about it. That I just think is a really responsible way of approaching the risk. And I think it would do a lot. If something bad did happen, it would help your case as the fitness professional and your facility quite a bit. So I don't know how often fitness facilities are encouraging their fitness professionals to be involved in that process. But if they're not, I think it would be a good thing.
Yeah. What I'm curious to ask about, at least from my, very, non-legalistic understanding, is a waiver doesn't necessarily protect you from litigation per se, correct? Like you could have somebody sign 6 different waivers, but that doesn't prevent you from being taken to court. So I think, at least that's my understanding. So I think it might be important to unpack that a little bit. What does a waiver and an informed consent do, but also, where does its ability to prevent litigation kind of stop?
Yeah. Well, some states don't like waivers. So it's going to vary state by state. But one thing that I think they've found, they being people, legal scholars, is that even if a state doesn't find waivers very favorable, that they have a deterrent effect anyway. So if someone signs a waiver and they know they've signed a waiver, they may be more hesitant to bring a lawsuit, even though if they do bring a lawsuit, a court might disregard the waiver. But the more informed that a client is about the waiver that they're signing, the more you can make it not an agreement that they don't read it, they just sign it, they have no idea what it is. The better you are off in making sure that waiver could be enforceable, even in states where waivers aren't looked upon very favorably. We call this a meeting of the minds, in contract law, where both parties are kind of like on equal levels. And the more you can bring the client up to a better understanding of what they're signing, the more equal level there's going to be between you as the fitness professional or the facility and the client who's signing the waiver. And it's going to be harder for that client to argue that, oh, I had no idea what I was signing. I didn't know what the implications were going to be. So what the waiver is actually doing is, telling them, hey, if something goes wrong, you've been warned that something could go wrong and you're willing to take on that risk anyway. And because of that, you will hold harmless. You won't find fault with the facility or your trainer. You're going to take responsibility. And so you aren't going to sue them for your injuries because we told you about the risks and you are assuming those risks. And so you shouldn't sue us. The more you can make sure the client truly understands that and then document that they've really understood that, is going to help. So yes, you're right. That doesn't mean they can't try. Like if they're so mad and they're going to take you to court anyway, even though they signed the waiver, they can still file a complaint. And they can argue to the court that that waiver was invalid. And maybe there's case law in the state that, that is in their favor, that where other courts have said, yeah, these waivers are invalid, but they're still going to have to spend money. Some lawyers still going to have to spend time on fighting that battle. And if the client and their lawyer know that that client had full knowledge of the waiver, full knowledge, because there's documentation supporting that there was a conversation held. It wasn't just given to them at the front desk and they just sign and they have no idea what it said. That is going to be harder case for that client and their lawyer to make to a court to say that that waiver was invalid. It's just going to be harder because of all those facts that are in support of the facility or the fitness trainer. So that's why, you might still get hailed into court, but your case will be a lot easier to fight if the more you do to make sure your clients are in full understanding of what their risks are and that they can't hold you responsible because they're taking on those risks.
Yeah, and that makes all the sense in the world. I think that's such a great point, that actual additional layer of documentation. What I am curious about is what happens when there is actual negligence. Let's say you did all of that. Somebody signed the waiver, you document that they understood it, and then the fitness professional does go out there and do something that is negligent. Maybe they knew the person had a diabetic condition and they pushed them to the point where they became severely hypoglycemic, fell over and hit their head. How much protection would all of that great documentation confer then?
Well, it depends on the language of the waiver. So, and this is where I think a lot of states will find waivers are not enforceable, is if they're waiving just regular negligence, like you should have known better, or gross negligence, or intentional conduct. You can't really waive intentional, like I'm going to hurt this client today. So the degree of negligence, I think, comes into play. If it was something like really, really, like anybody would have known better than this person did, a really egregious really off the standard of care that a fitness trainer should be operating under, a waiver may not help them in that case, because if it's going to waive something, it's going to waive gross negligence, or it's going to waive like negligent conduct, just really careless, it could happen to anyone kind of thing. But if it's gross negligence or intentional conduct, I don't think any court would allow a waiver to apply in those situations. I mean, they can try, and you'll see waivers that will try to waive gross negligent conduct. But it's a little bit more iffy because it's starting to cross the line into just almost intentional or just really, 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 really reckless, that like driving drunk, it's just, you should absolutely know better. And if you kill someone, it's just, it's not pretty. So it's going to depend on the level of negligence, the language used in the waiver, and the state that you're in.
Yeah. And I realize it's complicated. There's no easy answer on this. And that's why courts exist. And that's why lawyers exist, to be able to solve some of these more complex issues. Two kind of quick rapid fire questions I'm just interested to get your thoughts on. First one is, this is for the solo practitioners out there, people who have their own companies. You certainly can go to LegalZoom.com and get a waiver. You also can, search fitness waiver on the internet and probably find 30 of them. How we'll use the LegalZoom example, or just we won't say specifically LegalZoom. We'll say the online websites that allow you to purchase a waiver for your business. Is that a viable path to go, or should people be, coming to a specific experienced attorney to help them craft a waiver that is right for the parameters of their business?
Yeah, I've looked at LegalZoom and other platforms. And because what I do is so unique, I mean, if you Googled wellness law right now, what you would find, other than my law firm coming up, hopefully on the first page of Google, is wellness programs that are for law enforcement or law firms.
Got it. Interesting. Yeah.
It's not a recognized practice area yet. It's my goal, is to have it be. And so, of course, these companies like LegalZoom and others aren't going to have disclaimers or waivers or any language that's going to be particular to your industry. They're going to be very generic. And I mean, I wouldn't be surprised if there was any that would really apply to the healthcare industry, which, of course, is huge, and health law is definitely a legitimate and founded practice area. So it's going to be more for general corporations, just general business kinds of purposes. And I often find that those just don't work well. They just aren't tailored enough to what you're doing, specific risks that are involved with your particular industry. So I would encourage anyone who is in this industry to really look for more tailored documents that will help address the specific concerns of the fitness world.
Yeah, I think that's a great point. There's not a lot of institutional knowledge at some of the online-based companies of the industry. It's interesting you bring up the point of probably not even of the healthcare industry, which is a bona fide established industry, let alone fitness and wellness, which isn't. Brings me to my second question. This is for this is for the personal trainers that are employed by an organization. They're not 1099s. They're working in the 24-hour fitnesses and LA fitnesses of the world. How important, in your view, is it for that trainer to have their own separate liability insurance from that of the facility? Because they're almost always covered under the umbrella of the facility, but should they have their own separate policy?
Well, it's going to depend on what the policy that they are covered under by the facility says. I mean, most likely that policy carried by the facility will cover any actions that are done on behalf of the facility. And then that's in the facility's interest too, because as I mentioned, there are lawsuits where not only the fitness trainer is held accountable, but the facility is also brought into that lawsuit as, a defendant because they hired this person and maybe didn't give them the proper supervision or training, and they have the deeper pockets. So they're of course going to get pulled in. So it's in the facility's interest to make sure that their policy is covering their employees when those employees are working on behalf of the company. Now, to the extent that that trainer is maybe doing something on the side or outside of the scope of what they were hired to do, then maybe that policy isn't going to be covering them for those actions, and they might want to have something supplemental to that.
Yeah, fascinating. And this is such a fascinating area for me, Barbara. I feel like I can keep asking you questions for a very long time, but I want to be respectful of your time and our audience's time. And I want to start bringing this to a close, but I know there are people that are going to be listening that are saying, wow, this is really fascinating, an area I don't really know very much about. So if people want to find out about all the great stuff you're doing, and maybe if they want to get a hold of you, what's the best place for them to go to be able to find out about what you're doing?
Yeah, my law firm's website is really easy, wellnesslaw.com.
Mm-hmm.
And you'll find my contact information there. There's links to my social media. I have lots of blog posts and articles, and yeah, it's a great place to learn more about wellness law and the work that we do at the Center for Health and Wellness Law.
Awesome. And we will link up to all that on the show notes page so people have access to it. Before I let you go, I want to pose our final question to you, which is the one I always end the podcast on. And it's around the wellness paradox, which for me is this communication, collaboration, and trust gap between fitness professionals and the medical community. And you have a little bit of knowledge of both spaces. If you could give fitness professionals one piece of advice to close off that gap, what would that piece of advice be?
Don't be afraid to work with the healthcare industry. There are lots of initiatives that are trying to integrate them more. And I think it would be helpful not only for you as the fitness professional, but your clients to have more synergy with the healthcare industry, because the healthcare industry does not have the time or the energy or even the desire, to be honest, to be in wellness, but because of the restrictions that they're under, the payment systems. So I think if the fitness industry can take the lead in trying to be more reaching out and bridging that gap, that would benefit everybody.
Awesome. Yep. Reach across the aisle.
Mm-hmm.
Barbara Zabawa, thank you so much for joining us on the Wellness Paradox.
Oh, you're welcome. It was fun.
Well, I hope you enjoyed that conversation with Barbara as much as I did. If you found it insightful and informative, please share with your friends and colleagues. Those shares make a huge difference for us. Any information we'd like to share with you from today's episode can be found in the show notes page by going to wellnessparadoxpod.com/episode 68. Please be on the lookout for next week's episode when it drops on Wednesday. And don't forget to subscribe through your favorite podcast platform. Until we chat again next week, please be well.